That's right, Brandis. The Supreme Court returned to in-person today for the first time since March 2020, with the exception of Justice Brett Kavanagh, who joined by phone after testing positive for COVID. Now, the court's new term is full of high-profile cases, including hot-button issues like abortion access, Second Amendment rights, and religion. And joining us to talk about some of those big cases and how things have changed on the court over the last year and a half are Julie M.K. Siegel, a partner at Kirkland & Ellis and a former clerk to Chief Justice John Roberts. Aziz Huq, a professor at the University of Chicago Law School who clerked for former Justice Ruth Bader Ginsburg. And Matthew Hellman, a partner at Jenner & Block, who co-chair of its appellate and Supreme Court practice. He clerked for former Justice David Souter. Welcome all of you to Chicago tonight. Julie, I'll start with you. This is the first time, as we mentioned, that justices have been back in person for hearings since March of 2020. How has COVID changed oral arguments and how justices have interacted with these cases?
Well, one big change during COVID when the court was holding arguments over the phone was the way that the justices asked questions. So in the courtroom, they're used to asking questions in whatever order they want, often interrupting each other and the advocates. That wasn't really possible over the phone, so they tried out a much more orderly method of going in order of seniority, asking questions one at a time. And now that they're back in the courtroom, we're seeing an experiment with a little bit of a hybrid model. So for the majority of the argument, the justices are asking questions at will, and then at the end, there's more of a round robin format where they each have a chance to ask any final questions, again, in order of seniority. And one exciting thing we saw today was that Justice Thomas actually started off the questioning for the term. And that's noteworthy because before COVID, Justice Thomas went most arguments without asking any questions at all. And then he became more active during the phone arguments, and today indicated that he might remain active even though they're back to the courtroom.
I was just going to say, Justice Thomas had been silent for years until COVID when he started asking questions via the phone arguments. All right, Matthew, we mentioned so many high-profile issues in this term. Do you anticipate big, sweeping decisions on these issues that involve abortion rights, separation of church and state, gun rights, or do you anticipate more narrow rulings on these cases?
Well, that's really the question that a lot of people have been wondering. And I think it's useful to take a step back and look at where the court has been and maybe where it's going. For those of us who remember clerking, say, for Justice Souter, during that time on the court, it was often said that Justice O'Connor and Justice Kennedy were the swing justices. I don't think they necessarily enjoyed that term, but that's what sometimes people said, because on 5-4 cases, the ones that were close, they were often the justices that were in the majority. After Justice O'Connor retired, Justice Kennedy really had that mantle. And then when Justice Kennedy retired, it was the Chief Justice Roberts, who I think was most often in the majority. I think something like 97% of the time 2 years ago, he was in the majority in cases. Now the center justice on the court has moved a little bit, I think further still towards maybe where Justice Kavanaugh might be. And whether that will lead to broader sweeping opinions, I think is hard to know, but there are more ways to get to a broader opinion with the current composition of the court.
It certainly seems to be more of a 6-3 conservative majority, whereas, as you mentioned, in the past there was 5-4, where Justice Roberts, who is judicially conservative, would kind of be the swing vote on a lot of those cases. Aziz Huq, let's talk about a case that's getting a lot of attention, and that's the state of Mississippi's ban on abortion after 15 weeks. That is being challenged. What are the implications of a decision here for Roe v. Wade?
So Roe v. Wade, which is a case from the early 1970s, and Planned Parenthood v. Casey, which is a case from the early 1990s, together protect a woman's right to an abortion after up until the point that a fetus is viable. It's generally considered that viability occurs around 24 weeks. The state of Mississippi has passed a statute that prohibits categorically, with a few relatively narrow exceptions, prohibits categorically abortion after 15 weeks rather than 24 weeks. In doing this, the state of Mississippi is purposefully challenging not just the framework for analyzing abortion rights under Roe and Casey. It's really challenging the idea that the 14th Amendment to the Constitution protects abortion rights at all. So looking at Mississippi's brief in this case, which is called Dobbs versus Jackson Women's Health Clinic, Mississippi essentially doesn't try and argue the merits of its law under Roe or Casey. Its entire brief is focused upon the idea that Roe was wrongly decided. So that's the issue that Mississippi is trying to tee up. If the justices endorse Mississippi's position, obviously that will have sweeping legal implications, at least outside Texas, where SB 8 has already de facto prohibited abortion. And so we're likely to see a lot of anti-abortion criminal statutes kicked back in.
Julie, as Aziz is saying here, that this legal strategy is striking at the way the 73 Roe v. Wade law was decided. Does that mean there's a potential ruling here that would overturn Roe v. Wade?
Well, that's certainly what the state is asking for. I would note that one sort of interesting feature of this case is that the state's strategy seems to have shifted from the time it was asking the Supreme Court to hear the case to the merits stage briefing. So as Aziz was saying, the briefs now argue explicitly that the court should overrule Roe versus Wade. But when they were asking the court to review the case, they told the court that they didn't have to overrule any precedent in order to decide the case. So there's a little bit of an interesting dynamic there with the change in strategy, and we'll have to see how the court reacts to that.
Yeah, that's going to be interesting to follow. Matthew, another case getting a lot of attention, a Second Amendment case out of New York State. Explain this case and the ramifications here.
Sure. So the case is about whether or not New York can justify restrictions on carrying concealed handguns outside the home, concealed carried licenses, and what it takes to get one of those licenses in New York. But what's really going on from the court's perspective is, at this point, quite a few years back, more than 10 years ago, the court issued a major Second Amendment decision regarding DC gun laws and struck them down under the Second Amendment. And since that time, there has not been a big substantive Second Amendment case. And some members of the court have expressed dissatisfaction with that in opinions dissenting from the court's decision not to take those cases, saying the Bill of Rights has the Second Amendment, it has the First Amendment. We take First Amendment cases all the time. We should work out what the Second Amendment requires as well. The court hadn't taken one of those cases until recently, and that case went away for other reasons. But now they've taken this case out of New York about concealed permits, and what it will determine, or what it could determine, is how good a rationale the state needs to have to prevent someone from carrying a concealed weapon outside the home.
And we'll see what the ramifications of that would be, not only in New York but across the country. Aziz Huq, I want to kind of zoom out a little bit. You know, all these decisions are coming as trust in the court, or at least in the court's impartiality, or being a non-political actor, has eroded. You've got justices like Alito trying to defend the court, Coney Barrett out there making public statements defending the impartiality of the court. To what extent is this perception and this distrust earned right now?
I think it's very hard to call the court an institution that is impermeable, that is outside of politics. We've seen in particular in the nomination context, fights that are plainly partisan in nature over judicial appointments. And what we're seeing in both the abortion and the guns case is the immediate consequence of replacing Justice Ginsburg with Justice Barrett. So the fact is that the court and the country are divided over questions of constitutional rights and constitutional meaning in ways that track partisan lines. So I think it's better not to blame the court and better to think about the court in the context of a country that is increasingly polarized along DR lines, and where Democrats and Republicans have very different views of abortion, gun rights, religious liberty, LGBTQ rights, and the like.
And certainly the nomination and confirmation processes the last several years have been incredibly politically charged. Julie Siegel, as we mentioned at the top, you clerked for Chief Justice Roberts. It's pretty evident that this legacy of the court has weighed on him. His ruling in the Obamacare case several years ago was a bit of a surprise, but seemed to indicate his belief in incrementalism on the court. So how does this perception right now weigh on the way he might steer this court?
Well, one question is whether he is still at the center of the court, and it seems like maybe he's not. So we'll have to see how the court handles these really big hot button issues this year to see whether he is able to put together coalitions for more incremental decisions, or whether the court has an appetite to make more sweeping, broader rulings this year.
And as Matthew mentioned, it seems like Kavanaugh might be more toward where the center of the court is at this point. And Matthew, there's another very heated case dealing with the separation of church and state coming out of Maine. Explain this case for us.
Sure. Well, this is a follow-on to a case that the court decided recently coming out of Montana, and it deals with when a state can decide that money it provides to educational institutions can or cannot be spent in religious institutions. Or I think as this case deals specifically, religious institutions or institutions affiliated with religion that have religious instruction as a core component of what it is that they teach. And in the Montana case that preceded this one, the court held that Montana couldn't limit its funding just to secular schools. It had to allow funding for scholarships and the like for religious schools. And this next case out of Maine is the next step forward, because they left open in the Montana case what happens if it's not just a religious school or a school affiliated with a religious institution, but one where there's a religious education.
All right, so many high-profile cases to cover, and our thanks to Julie M.K. Siegel, Aziz Huq, and Matthew Hellman. Thanks so much for joining us.
Thanks for having me.